I'm so pleased to be joined by an attorney who's right here in Gainesville, beautiful downtown Gainesville, and who's a double Gator, a graduate, both undergraduate and law degrees from the University of Florida, Gary Edinger. Gary has a really interesting and diverse civil practice that I'm hopeful he'll share a little insight about. And we're specifically here to talk about the unique First Amendment issues that arise in the regulation of adult-oriented businesses. So Gary, thanks so much for sharing your expertise with us. And maybe start off by just telling the folks a little bit about the practice that you do, what the mix of cases on your plate looks like.
Sure. So a couple things to say starting out. I love my job. So for me, it's not work. I look forward to coming in on Mondays to do what's on my plate. And I understand that's very unusual for our profession. Part of it is because it's just really interesting work. The law changes, like on a weekly basis. Most of our cases are litigated in federal court, which has challenges of its own. And so it's that combination of cool stuff to work on and an extremely challenging practice that just make me love what I do. So I didn't start off by doing this. There's like no such thing as the job description First Amendment attorney. It's just not a thing in our practice. So I started in Gainesville, the small firm. And over the years, I have done everything that an attorney can do, from family law to evictions to bankruptcy work, transactional work, contracts, litigation of all kinds. One day, however, one of the partners came in and said, guess where we're having lunch? And it turned out it was Cafe Risque. So for those of you students, who know something of our area, it's a long-term fixture in Alachua County. It happens to be that business is as unique as my practice because it's a fully nude restaurant with no alcohol. So that's a format you just don't see in the world. So we went down there, had lunch, and we entered into some litigation on behalf of that client. And back in the day, when we literally did not have the internet, word got around because people would look you up in cases, and then they would try to contact you that way. So my practice built up because no one else does this work. And there are a lot of adult entertainment establishments and other First Amendment needs around, and they find a way to get in touch with you, and a practice grows that way. But it's not something that you start out doing. But the other thing is that even for my colleagues, very few of them get to do this work on a full-time basis. They'll have maybe a couple of cases a year, or they'll specialize. I have some friends that do a lot of internet work that is adult oriented or politically oriented. But what pays the bills is just plain old internet contracts and copyright stuff. So even amongst my peers, and there are only a couple hundred of us in the United States, even among them, very few of them do this full time. And I'm blessed with doing what I would consider First Amendment oriented work, about 85% of my practice, and it's just awesome.
So in that practice, you've represented adult businesses in a number of cases, including some that have actually made some new legal precedent. Can you talk about that work and about some of the legal principles that come into play when you have a government agency that tries to say you can't have nude dancing in this county, or you can't have nude dancing in an establishment that serves alcohol, or some other type of restriction on adult entertainment?
Sure. So when you do First Amendment work, by definition, your clients are controversial. So I do the entire gamut of First Amendment practice. I do defamation work. I do a lot of commercial billboard and solicitation work. But really the heart of the practice is adult entertainment of one kind or another, simply because it's so controversial. And as a result, you can guarantee if you open a new business, it's going to generate a reaction from local government, particularly here in the South, where we're just a little bit more conservative than elsewhere in the country. And so it's a sophisticated practice. So sometimes I'm called in to give advice before a business opens. And when that happens, we're looking for loopholes. And I'll give you an example of one. This was for my Cafe Risque clients. They opened a club in Tallahassee, I think the city of Tallahassee, which had an ordinance prohibiting topless dancing. It did not prohibit bottomless dancing. And because one of the hallmarks of this industry is creativity and pushing the envelope, voila, they had a bottomless dancing club for about, a week before they changed the law. So sometimes we try to view these things in advance to set up the best possible case. Many times we open and file a federal suit the same day. And then sometimes we're reactive. So a new ordinance is passed, they arrest people in clubs. So the way that we get into it varies, and it also chooses in many ways how we respond. So for instance, one of the things that we look at is what court can we file in, because it makes a huge difference. So because these are politically difficult cases, and because in Florida we have elected judges who live in the community, it is a very difficult thing to litigate these issues in state court. So you might think, well, the First Amendment reads the same in Florida as it does everywhere else. But that's not how the real world works. And so we're having to deal in state court. We were dealing with a number of disadvantageous factors. One is political pressure on the judges, which can't be ignored. It's a real thing. And another is, it's not really an easy way to say this, but let's say the quality of judges varies greatly in the state system. And even judges who are very bright, capable people, they don't encounter these cases very often, maybe once in an entire career. And so they're just not good at it. And in contrast, when we litigate in federal court, we're dealing with judges that sit for life. So they have their own biases and perspectives, but they are largely removed from that political controversy, And also they tend to be brilliant people. And what I always say is if your federal judge is not himself brilliant, his law clerks are. And so you just get a better quality of decision. And to me, it's much more pleasant to practice in that venue because you're dealing with judges who understand what you're talking about, and you don't have to educate them. So plenty of times I've had to go into court where the judges probably knew less than your students about the issues. So there are a tremendous number of factors just in plotting the strategy on how these cases are to litigate. And then when we come to the actual law, as I said, it changes so fast and often so dramatically that, I'm learning all the time. And I'm an intellectually, academically oriented guy, kind of geeky. And so for me, the constant research and learning, I love it. It's one of my favorite parts of the practice. I've had the ability to make law from time to time. And because it's cutting edge stuff with the rules changing all the time, we make law from time to time. So my firm, we always make fun of ourselves. We do all this litigation destroying the First Amendment because these are difficult cases. And particularly with adult entertainment, we usually talk about maybe like 3 different issues. The one where I've done well and set some new law has to do with licensing. So that's one of the tools government brings to the table. So you're not allowed to dance nude without a license, or the club can't put on that production without a license, and then government just doesn't give you the license. So a great deal of litigation's involved with those issues. It's kind of my specialty. There's a particular case out there called Lady J Lingerie versus Jacksonville that kind of set the standard on that. There are also other issues which have to do with like zoning, because you don't want these businesses going in necessarily next to a school or a church or what have you. We call those sensitive uses in the trade. And so we have a lot of litigation over that. And one of the interesting things about this area of the law is that with zoning, for instance, you wouldn't have a zoning law that says you have to have at least 5 gas stations in your town. But under the First Amendment, we have to have guaranteed access to speech, which includes adult entertainment. So government is put in this unusual perspective of having to specifically allow businesses that they detest. And so naturally that draws some litigation. And my firm has one of the leading cases that destroyed the First Amendment for those challenges, called David Vincent. So I'll give you a quick anecdote out of that case, and then we'll move on a little bit. One of the issues is there enough land available where you could actually open a club and disseminate the free speech? So in David Vincent, the issue was how many sites are available? And one of the sites that counted was a borrow pit. So students who are from around here or maybe parts of Central Florida know that borrow pits are holes in the ground where they've removed fill dirt or phosphates or what have you. So it's not land. You actually have to bring land to it to create a site, but that counts under our laws. And then other issues that we deal with adult entertainment are not every day. They have to do with really sophisticated issues of, we call it content-based legislation. And there's basically, I call it a sex exception to the First Amendment, where government doesn't have to raise to the same standards when regulating there as they would for newspapers or television stations, that sort of thing. It's called the doctrine of secondary effects. It's absolutely unique to adult entertainment. You don't find it anywhere else. And we also deal rarely, but from time to time, with obscenity, which I understand is something your students have studied this semester.
Yeah, so actually, to just reinforce something you mentioned about secondary effects, right? That's actually an argument that's been had in some other contexts, like, for instance, video games, right? There's been attempts over the years to legislate content of video games on the grounds that somehow this causes people to act in antisocial ways. And so far, the courts have been unreceptive to that. But when it comes to adult entertainment establishments, there has been receptivity to this idea that somehow when you have an adult business in the neighborhood, that's going to bring crime, that's going to bring drugs, that's going to bring prostitution. And so on that justification, restrictions that would never fly, as you say, if it was a book or a movie or a newspaper, have been allowed to fly in the adult entertainment field.
So let me follow up on that for just a
Yeah.
sec, because it is interesting. We think of the First Amendment as some sort of absolute bar against legislation, and we think that it means the same thing in all contexts, and it absolutely does not. So secondary effects is very meaningful here. So I was talking about the fact that the law changes so quickly. So I think in 2017, there was a major case out of the Supreme Court, Reed versus Town of Gilbert, which kind of upended what it means to be a content-based law. And what it boils down to is if the law makes distinctions on what is said or who the speaker is, it's immediately suspect and usually falls under strict scrutiny and usually fails. And so Reed was kind of a reminder to us that the courts really take that seriously, and that by and large, government shouldn't be legislating at all based on what people say or the identity of the speaker. The exception, though, is still for sexually oriented speech. And we all got excited when Reed came out, people who do what I do, and we thought that this was going to reset the bar and make it a little tougher on government to do some of the ridiculous stuff they occasionally do. But we find out, no, the courts were not very receptive to that. And they say, well, yeah, Reed applies to everybody else, but not to you guys. And so that's a significant thing and very difficult to explain. We've written law review articles on this subject, trying to develop something that makes consistent sense in First Amendment doctrine. And the answer is it just really does not. And so you're also right that because there's always a tension in First Amendment litigation where people push the envelope, we've seen governments try to use secondary effects in places where it doesn't work. So for instance, one controversial use is church daycares. So a lot of churches are located right next to residential structures, and daycares make very bad neighbors. And so there had been arguments trying to push secondary effects out into that field, and the courts have shut them down. You mentioned violent video games. There's also something disgusting called crush videos that involves secondary effects, and the Supreme Court has pretty steadfastly refused to expand that doctrine. But it shows you both, it has real world implications, changing case law, and really sophisticated, fun stuff to do.
So I think this is going to be kind of mind blowing to people who think about the First Amendment as being something that we've had for 250 years, written by a bunch of powdered wig guys. We've had adult entertainment for many decades. You would sort of think that the cement has dried by now and that we know everything that we could ever know about the law of the First Amendment. But in fact, you're describing an evolving set of standards. I wonder if you could talk a little bit too about what you see just going from jurisdiction to jurisdiction, because even though you're located here in Gainesville, Florida, your practice is quite widespread. And I would imagine you find yourself in front of a real diversity of judges and juries. You kind of alluded to this earlier about the conservative nature of certain communities in the South. And how does that play into both your strategy as a litigator and also the kinds of outcomes that you're seeing?
Well, unfortunately, it has everything to do with those issues. And so sometimes it's literally to the point where you tell your clients, don't go into that jurisdiction because the laws are hostile, the police are hostile, and the courts are hostile. And sometimes you just have to have that conversation. It's most fun for me when clients say, but I really want to go there. And then I have a good fight on my hands. So we've gone into communities, for instance, I'm thinking Mobile, a couple of little tiny towns in Arkansas, some places, Mississippi. Those are tough jurisdictions, and you have a fight on your hands going to those. You're right about my practice, which is another thing that's really interesting. So as you can imagine, I don't earn my living from cases in Gainesville. I get them, once every couple of years. And I like to, that's a point of pride, by the way, because we live in a progressive university town. Our police are relatively well trained, and the issues that come up in other jurisdictions don't come up here. Jacksonville keeps me really busy. I've been to war with them for 30 years. I have a case before them right now. But you do have to know where you are, and surprisingly, the law will vary dramatically from jurisdiction to jurisdiction. So my practice is throughout the Southeast. I've had cases also Colorado, Pennsylvania, New York, Arkansas. So I've been in a lot of jurisdictions, and on fundamental issues, like I had mentioned, licensing issues, the 11th Circuit, where we're located, is extremely conservative across the board on many issues, including hot button cultural issues. But we happen to be very progressive and advanced when it comes to the law of prior restraints, which is something that comes up in journalism all the time. The Fourth Circuit has gone a bit different way than us. So they are also a conservative circuit. That's South Carolina, North Carolina, Virginia, Maryland too, I think. And but they have a very underdeveloped prior restraint law, and they have gone a very different direction. So here, for instance, you have to guarantee a prompt hearing and have very specific criteria. Those same standards aren't the same in the Fourth Circuit. So we're dealing with the same First Amendment. It's been around, as you say, for hundreds of years, and you get different results in different communities just based on whatever the jurisprudence is there. And so you have to learn the law of the land essentially wherever you go.
And this is something we actually talk about at the very outset of the course, which is that even though we spend so much of our time in the classroom looking at US Supreme Court cases, it's really those lower courts that put the meat on the bones that the Supreme Court sets forth. The Supreme Court speaks in broad generalities, and it's up to those lower courts to apply those and to fill those in fact-specific cases. And you do find, because 99.9% of cases never make it up to the Supreme Court, that in fact there is a law of the 11th Circuit, a law of the Fourth Circuit, a law of the Fifth Circuit that can be quite different, and it can be determinative of your outcome. And as you're describing, can even be determinative of your business strategy. Where do I choose to locate might actually be influenced by the legal precedent that my appellate judges have set.
Exactly so.
That's fascinating, yeah. So I guess turning to kind of the modern day and what we see on the horizon for the future, the biggest single change in the adult entertainment industry has been the internet, the ability to get adult content right at your desktop or into your phone. what do you see going on in that field in terms of the way that the law is developing and how legislatures and Congress are responding to political pressure to restrict access to adult material?
So that's neat stuff. And actually, that is where the new law is coming from. Because by and large, when we're dealing with brick and mortar stores and clubs, most of the law has been set. So there are variations on the theme, and it varies from jurisdiction to jurisdiction. But there's not a whole lot new under the sun. But the internet's a different story. And so we see two different drivers on the internet. One is legal and one is practical. So as you can imagine, pornography is widely available on the internet for free, or more or less for free. And so that's had a dramatic effect on bookstores in particular. So there's almost no such thing as the old style dirty bookstore or little mini theaters, we used to call them, where what they do now primarily is sell adult toys, dildos, basically. And people still like to come in and touch them and, see what they look like. So it's different than shopping on the internet. But because movies and downloadable content are so widely available, adult bookstores have suffered in the same way that Walden's bookstores or Borders bookstores have, which is all those are out of existence. And so it has real world practical implications, which also changes, the interaction between local government, because there's no bookstore to push against if you want to legislate and you're a local congressman or council member. On the internet, there's still a lot of developing law, not just on adult entertainment side, but on, for instance, schools cases, what we call true threats. So it used to be back when you and I were younger men, that there was a case called Tinker that gave a lot of protections to student speech. That doctrine has been severely eroded away. And now one of the hot button issues is, what if a student says something controversial about his principal or their teacher or classmate on their home Facebook page? They don't direct it to the school. It's not on a school facility or website, their own personal communications. Well, the courts have been very receptive now to discipline the students for stuff they say privately. And that would just be unheard of in a world that didn't have the internet. When we're dealing particularly with adult entertainment and obscenity, that's very much in flux. So not just in terms of legislation, but in terms of practicalities again. So one thing that we had been advocating for, one of the Miller standards has to do with local tolerance. Right? What is the local community standard? There had been a push across many jurisdictions to say, hey, we live in an internet age, and the standard ought to be national because these materials are available from, Topeka to Tulsa. And so we have not had a lot of receptivity to that in the courts. And with our current Supreme Court, that's not going anywhere. But it's an issue still that's being hotly litigated. We also see pushback from Congress. It's been in the news like every day. Our temporary president doesn't like 230 immunity very much. So many people see that as the core of internet freedom. It certainly offers a lot of protection for adult speech, but Congress is seriously thinking about changing those rules. Also, what's sexier, or what the cutting issues are in the cultural world changes over time. Again, back when we were younger men, it had to do with feminism and Professor Dworkin's crusade against pornography. It then became, Save Our Children. And so the current hotbed or hot topic has to do with human trafficking. And so that has led to some federal legislation recently called, I can't even remember actually.
FOSTA, right?
FOSTA and SOFTA or something like that. So those are trying to shut down internet services like Backpage that people believe are used for escort services and prostitution. And that in turn has a bad impact on society, not just because of the moral issues, but because of a tie to human trafficking or perceived tie. And so the long and short of it is that the law never sleeps, and particularly in this area. And it's exciting stuff to do on a daily basis, and to have the privilege of doing it professionally is just awesome.
So in the closing few minutes that we have, I wanted to pivot a little bit because you told me that your practice also includes litigating in the area of things like sign ordinances, another area where local government regulation collides with the First Amendment. We're going to spend a fair amount of time in the course talking about commercial speech and about how First Amendment challenges play out when the government tries to restrict not so much what you can say, but how and where you can say it. And so what are some of the cases you've been involved in that area? And is the law pretty well settled about where the government's authority begins and ends?
Many times the law is pretty well established, but it's very fact intensive. So when we're dealing with content based, that's a higher level of abstraction. When we're dealing with time, place, and manner restrictions, like you're talking about, how does the speech go forward? That gets really into the mud and is very fact intensive. And so in my practice, I do a lot of work with billboards, which for whatever reason are controversial. There's always a constituent in every community that it just hates them. And so I have one of a primary case in that in our circuit called Cafe Erotica versus St. Johns County, which involved some political posters saying Karen Brunel is an incompetent public official, I think was one of them. And Karen Brunel came out and cited her own sign, which was kind of amusing. So that sort of thing comes up, and sometimes it's politically oriented. More often it's a matter of, dollars and cents commerce. One area that I've been extremely active in lately is in commercial solicitations, face-to-face solicitations. So if you think for people who still go to malls in a COVID world, there are often kiosks there with highly aggressive vendors that come up and put perfume in your face and that sort of thing. So that's First Amendment protected speech, that kind of hawking, as we say, face-to-face solicitation. It's extremely, a lot of governments don't like that, and they legislate against it. And so there's pushback from First Amendment interests. A case I was involved with there was FF Cosmetics versus Miami Beach. So it's wonderful to do these cases because you get to make new law. And of course, there's the good old conventional First Amendment, which also I practice in. And defamation would be important to your students because they may face that in their daily lives. And also good old-fashioned political demonstrations, Black Lives Matter. So those are difficult issues. They're very fact-intensive. And unfortunately, I've set some law on that as well. We had a case before the Supreme Court. Unfortunately, I didn't get to argue it, which is just as well because it was traumatic experience. But Thomas versus Chicago Park District had to do with permitting of demonstrations or First Amendment events of one kind or another. So this is an area that has limited availability for private attorneys. It's more like an ACLU thing. I do it from time to time, but for me, it's a pro bono thing. The days when we used to be able to recover attorney's fees are long gone in that area because of a case called Buchanan, which we could talk about for 30 minutes. But the long and short of it is that this particular practice is fascinating. For those of your students who actually practice in the field of journalism, it's wonderful because it's the embodiment of the First Amendment, and they're living this stuff on a daily basis, and occasionally they make law. So, one of the hotbed topics there was recording of police. So for quite a number of years, it was very controversial across the circuits whether citizens could film police in the course of their duties. Now that's fairly well-established law. But that's something that, is vital to the press. And so these battles are fought every day, and maybe your students will be part of it someday.
Yeah, and you raise such an interesting connection between the work that you're doing and the work that today's journalism students will be doing, because even though those students are beneficiaries of the First Amendment, so often the First Amendment battles that we see playing out in the courts today are not about traditional journalism. They're about the type of clients that you're talking about here, whether it is the crush videos in the US, the Stevens case,
Right.
whether it's the Westboro Baptist Church protesters, whether it is the people who engage in adult businesses. Those are the people who are sort of staking out the outer limits of the First Amendment, from which everybody, people in advertising, people in public relations, people in journalism, all benefit. But the cases that are kind of establishing the outermost limits where the First Amendment begins and ends frequently are the cases involving your clients.
That's very much true. So in the old days, it used to be what Krishnas and Jehovah's Witnesses. These days, all the new laws made by adult entertainment. And it's just because that is the controversial leading edge between society and the First Amendment. So you look to see where that controversy is, and that's where the new law is made.
The people who push the boundaries are the people who expand the boundaries. So
Exactly.
that's a fun area of the law to litigate in. So, well, Gary Edinger, thank you so much for sharing this really interesting look at your practice and some insight about the way the First Amendment really works on the ground. I can tell my students about the Miller test, but it's so much more interesting for them to hear from somebody who's actually had to go out there and fight it out in the courtroom and apply that test in everyday life. So thanks so much for sharing that expertise.
My pleasure. It was fun. Thank you.